First, we want to take a look at financial roles within an organization. So just because you have an employee in some sort of finance related position in your company, such as accounting or payroll, someone who has access to financial data and maybe even the ability to make financial transactions, they're not necessarily going to be exempt from the restrictions of the new law. You're still going to have to meet specific statutory criteria for exceptions. As I said, this is going to require a role by role analysis. And by extension, that should mean that if you do find that a particular position is exempt or that an exception applies, you should document that exception and the basis for it. What are some of these relevant statutory conditions for related exceptions in this particular area? There is an exception if the employee is required to be bonded under state or federal law. There are certainly some government public sector positions where people are required to be bonded. Whether or not the bonding requires a credit history report is kind of irrelevant. The law says if they're required to be bonded, then they can be asked about their credit worthiness and the like, or you can obtain a credit history report on them. A separate exception would be where an employee has signatory authority over third-party funds or assets valued at $10,000 plus. The key condition here is third party. Um, and that means that you are talking about not the company's money, but some outside party's money. This is really going to try to address banking situations or other financial positions, not necessarily meaning that someone works in finance within the company as much as that someone works in the finance industry per se. However, there could be circumstances where your company does have access to third-party funds or assets, and they have the authority to sign off on those. For example, a law firm may have trust accounts for their clients where they have the authority to spend their clients' money held in trust, and that could exceed $10,000. So the people who have the authority to sign those checks would be accepted from the prohibition on credit history inquiries and reports. A separate but similar exception applies if the position involves fiduciary responsibility to the employer with the authority to enter financial agreements valued at $10,000 or more on the employer's behalf. So this is kind of the flip side in a sense to the third party funds, still the $10,000 level. These are going to be more applicable to some companies outside of the financial industry. There is, I believe, an expectation that this is a somewhat regular authority, not that just this one time this person was authorized to enter into an agreement that happened to be worth more than $10,000. So you would want to be looking at someone with general purchasing authority, for example, or could be a sales agreement as well. But it's not going to be your rank and file employee in most positions within the company.